of tiered penalties that will ensure an overall consistency for future breaches. And in tackling the too lenient view, the guidelines ensure that the fines will have an impact on the organisation to ensure that there has been effective punishment, if you like. So what do we know? The guidelines came into force from the 1st of February this year, and it applies to all cases that are sentenced after this date. Now, just to clarify to everybody, if an organisation or an individual has been found guilty before the 1st of February but are yet to be sentenced, sentencing must follow the new guidelines. So, one of the questions that we get asked quite a lot, or quite considerably, is, do they really apply? Aren't they just guidance, you ask? Well, the Coroners and Justice Act 2009 states that every court must, in sentencing an offender, follow the sentencing guidelines which are relevant to the offender's case, and must, in exercising any other function relating to the sentencing of offenders, follow any sentencing guidelines which are relevant to the exercise of the function. In layman's terms, courts must follow these guidelines. They must give specific reasons if the sentencing guidelines aren't followed. They've got to be really good reasons for not following the guidelines. So what we're going to do this afternoon is we're going to take a quick look at the guidelines for organisations to start off with, and we'll be concentrating on employees' breach of duty to employees and non-employees and breach of health and safety regulations. We're also going to be looking at individuals' breaches of duties towards other employees and non-employees, a breach of duty of self-employed to others, and a breach of duty of employees at work. And then we're going to take a very quick overview of the sentencing guidelines for corporate manslaughter themselves. I'm going to concentrate today predominantly on the organisations and the individuals, but I am going to put up some slides detailing what the sentences are for corporate manslaughter as well. So just to start off with, to kick us off, we're going to be talking about organisations. Now, the starting point for when a court is sentencing organisations, the first thing that they need to do is to determine the level of culpability that the organisation has. And it's based on the following. So what we've got, to start off with, a very high level of culpability, which is a deliberate or flagrant breach of health and safety legislation. The next category down is high, and an organisation may fall into the high category for failing to put in place measures that are recognised by the standards of the industry. Other examples of falling into the high category could be ignoring concerns raised by employees, failing to make appropriate changes following to prior incidents, allowing breaches to subsist over a long period of time. We've then got a medium category, which, if we interpret it a different way, systems have been in place, put in place by an organisation, however they have not been sufficiently adhered to or implemented correctly. And then finally, we have a low category. The failings were so minor and occurred as an isolated incident. Efforts were made, however they were inadequate on this occasion. So the first thing the court does is we need to determine the level of culpability that the organisation falls into, and it's got to be one of those 4 different categories. Once the court has decided what category they're falling into, what we then look at is a following table. Now, the key thing is here, we need to determine the level of risk of harm that is being created by the offence itself. So along the table at the top, we've got a category, we've got level A, harm, which involves death, physical or mental impairment. Level B, physical or mental impairment. And then C, which is all other cases not falling between A and B. And down the left-hand side, we've got the likelihood that the harm could occur. We've got high, medium, and low. Now, the key word to this table is harm risked, and I'm underlining harm risked because the offence is creating a risk of harm. This is a key definition as the previous sentences for health and safety breaches were based on actual harm done. So I've got an example. Let's say that somebody falls from a ladder that's 10 meters up in the sky, and they fall and they break their legs. The previous fines for the breach will be based upon the severity of the injury. The new guidelines are based on the harm risked. Means that there's a strong chance that if somebody fell from a 10-meter ladder, that there's a chance that they could have been killed. So we'll be looking at a Category A offence. So sentences will be issued accordingly. Now, one of the steps also is to designate the likelihood of harm, and it's either high, medium, or low. Now, the problem is that high, medium, and low are prone to wildly different interpretations. Let's suppose that experts agree that there was a 1 in 10 risk that someone would have been killed or disabled by falling from a walkway throughout the period of the breach. Even with such a precise expert view, is that a high, a medium, or a low likelihood? The court would struggle to answer that question, I think, without understanding the wider circumstances, such as looking at culpability and what actually happened. But those factors are intended to be excluded from this stage of the calculation to make the progress rigorous and fair. After we have decided the level of harm risked, the court then needs to decide if any of the two following factors apply. And they are whether the offence exposed a number of workers or public to the risk of harm, and whether the risk itself caused actual harm. Now, logically, it's very difficult, because if you think about it, it's very unusual to expose only one worker to risk. So how they apply it is that if one or two of these factors apply, then the court must consider moving up a harm category. After then we have decided the culpability and the level of harm risked, what the courts then do is they must decide the category that the organisation will fall into, and it's based on turnover of the organisation itself. So we've got different categories. I'm going to put them up. So we've got, to start off with, we've got a large organisation that has a turnover of greater than £50 million. A medium organisation which has a turnover between 10 and 50 million. A small organisation with a turnover between 2 and 10 million. And then finally a micro organisation with a turnover of not more than exceeding 2 million. Now the thing is that organisations must provide details of their accounts for the court. If the organisation fails to provide any details, then the court must assume that the organisations will be able to pay any amount. And accounts must be provided for the previous 3 years. We can then look at the sentencing guidelines for the different categories of organisation. So what I've done is I've took a snapshot of the sentencing guidelines for each different category of organisation. So what we're looking at first is we're looking at a large organisation. And for this example, we will assume that this large organisation with a turnover of equivalent to £50 million and over has been found of having a very high culpability. Let's assume that in the harm table, they've been put under Category 1 of harm as well. So, which is a flagrant disregard for health and safety, and there's a high risk of death. If we look at the fine starting point, the very top line, it's £4 million. But the offence range, the category range, is between 2.6 and £10 million. If we use the same example for a medium organisation, so with a turnover of between 10 and 50 million, then the starting point is £1.6 million, and it's got a category range of between 1 and £4 million. So again, with a very high culpability and a harm category of 1. If we move on and look at a small organisation, again, for a high harm category and a very high culpability, we're looking at a starting point of £450,000 and a category range between 300 and 1.6 million. And then finally, we'll have a look at the same example for a micro organisation. and we've got a starting point of £250,000 for the fine and a category range between £150,000 and £450,000. Now, there is a final category that you could fall into, and it's a very large organisation. Now, that is an organisation that greatly exceeds £50 million turnover. The guidelines themselves, they don't specify a sentencing amount for somebody in this category, but they do specifically say that it may be necessary to move outside of the suggested range to achieve a proportionate sentence. In other words, in my opinion, all bets are off. I think that we could possibly be looking at 20, 15, 25 million pound fines for organisations that fall into this category. Now, the level of fine itself, it should reflect the extent to which the offender fell below the required standard. The fine should meet, in a fair and a proportionate way, the objectives of the punishment. Deterrence and removal of gain derived from the commission of the offence. It should not cheapen to offend. It should not be cheaper, to offend rather than take the appropriate precautions. The fine must be sufficiently substantial to have a real economic impact, which will bring home to both the management and shareholders the need to comply with health and safety legislation. Now, the profitability of the organisation as well is relevant itself. If an organisation has a small profit margin relative to its turnover, downward adjustment may be needed. However, if it's a large profit margin, upward adjustment may be needed. What I've put up on front of you, the slide, is a recent case where Balfour Beatty have been fined £1 million following a fatality at work. So I'm just going to put up the article and read it out to you. It says, at the sentencing hearing on the 25th of January, the defence pointed to the company's poor financial situation. The firm had losses of £150 million in the first half of 2015, despite a turnover in excess of £4 billion. However, Judge Adele Williams pointed out that Balfour Beatty's Group Chief Executive's salary was £1 million a year. So they set the starting point for the fine at £1.5 million and reduced it by 1/3 for the guilty plea. What happened in this case is, although this was sentenced on the 25th, before the guidelines came in, the judge, the court, sentenced as per the guidelines are going to look like. So they take into account the turnover, but obviously the high salary that the CEO of the company has played a factor in deciding the outcome. So that's a quick overview of how an organisation may face punishment. So what we're going to do now is we're going to move on and we're going to look at the individual's fines. It's the same principle, the same procedure that we're going to be following. First things first, we need to find the level of culpability. So you can see that we've got different categories, very high, medium or low. Now I'm just going to leave that on a minute for you just to have a quick glance over. But the key thing for me here is very high and high itself. I think it's quite easy to make the step up depending on what approach the court makes. Is there much difference between a high category, which is actual foresight of, or willful blindness to, risk of offending but risk nevertheless taken, or very high where the offender intentionally breached or flagrantly disregarded the law? So depending on what the court's approach is, I think if you're in the high category, you could quite easily find yourself being bumped up into the very high category itself. So after, again, we've decided the level of culpability, we go back to the harm risk table. Now remember, we breached the Health and Safety at Work Act by exposing people to the risk of harm, not actual harm itself. Now the same factors apply to what we've previously talked about for stepping up a category as well. So if we've exposed more than one person and whether actual harm was caused, we would need to bump up a category. So let's have a look at some of the sentences that we could possibly face. Now, so this is for the individuals. So what we've got, if we look at the very same scenario that we've been applying to an organisation, let's assume that the individual has been found of having a very high culpability and they fall into the harm category 1, which is the risk of death. The starting point for the sentence is an 18-month custodial sentence, but the range is between 1 and 2 years. Now, if you look at all of the categories that we're looking at for very high, high and medium, if you're in harm category 1 or 2, in most of the cases, you're almost certainly looking at a custodial sentence. Now, if they issue fines, the fines need to be proportionate as well. So again, the courts will ask to see financial information of the individual, the offender. If no information is provided, the courts will assume again that the fine can be paid at any amount. I want to just quickly nip back to the harm risk table again and just talk about another point. Now, I think if you're below the red line, which I've just drawn on the actual table itself, and even if you get bumped up a category, I think that you're looking at a possible fine. And I'm going to put another line up now, a blue line. I think if you're below the blue line, you're on the verge of a custodial sentence. Now, if you're bumped up a category for exposing more than one person to harm, it's probably nearly certain that you're going to be looking at a custodial sentence. Now, the one thing that I've not done with this webinar itself is I've not put any details about the potential fines that individuals can face. I've concentrated on the custodial aspect. But there are different categories that the fines would fall into. And I've got 2 examples for you. So the lowest band, which is a band A fine for an individual, the fine that you will be looking at is 50% of the relevant weekly income of the offender. The highest band, which is a band F fine, you are looking at a fine of 600% of the weekly income of the offender. So it's quite a high amount. Now, if you take, for example, the CEO of Balfour Beatty, who's on £1 million a year, that's quite a hefty fine that he's going to be issued with. Moving on now, what I want to do is I want to have a look at the possible fines from a corporate manslaughter point of view. So I'm going to put the table up from a corporate manslaughter. So again, it's based upon the category that the organisations fall into. Now, by definition, the harm and culpability involved in corporate manslaughter will always be very serious. Every case will involve death and the corporate fault at high level. So when assessing, the court should look at the following factors affecting the seriousness of the offence within the context by asking, firstly, how foreseeable was the serious injury? Then we would ask, how far short of the appropriate standards did the offender fall? How common is the kind of breach in this organisation? And was there more than one death or a high risk of further deaths or serious personal injury in addition to the death itself? For a Category A offence, answers to A and D must indicate that there's a high level of culpability. A Category B is where it indicates that there's a lower level of culpability. So let's have a look at the worst case scenario in the table that you've got in front of you. For a large organisation with a turnover of more than £50 million, a Category A offence has got a starting point of £7.5 million. And the category range itself is between 4.8 and £20 million, which is a considerable amount of money. Bearing in mind that the same applies to very large organisations that we talked about earlier. So potentially we could be looking at sentencing in excess of £40–50 million. Now, the last thing that I'd like to do, because I know that we've had a brief stop on corporate manslaughter, I want to have a look into some factors that may reduce the sentence itself. And first things first, I'll put it up for the organisation. So we've got some of the following factors that can reduce the seriousness or reflect mitigation. So let's say the organisation hasn't had any previous convictions and there's evidence that they've taken steps to voluntarily remedy the problem. There's been a high level of cooperation with the investigation, beyond that which was always expected. And what I'm really going to be talking about here as an example, perhaps Alton Towers. Now, what happened at Alton Towers last year, I know it didn't result in a fatality, but 2 people were seriously injured, they lost legs, and a couple of other people had suffered minor injuries. Now, if you look what Alton Towers did, they came out to the press, admitted liability from day one, and they've been working very, very closely with the HSE. So they're going above and beyond, perhaps, what's expected of them, and that will reflect when it comes to the sentencing. Now, the next box that I'm going to put up is a bolt-on for the organisations, and it comes into account when it comes to corporate manslaughter. And it's one of the things that we need to consider. Now, it's about whether the victims themselves have contributed to the actual death. It does say that the actions of the victims are unlikely to be considered contributory events. It says that offenders are required to protect workers or others who are neglectful of their own safety in a way which is reasonably foreseeable. So if somebody else has contributed to it, the victim, it will not be taken into account. Let's have a look at some factors that can affect an individual then. So again, you've got sort of the same principle, so no previous convictions or no relevant previous convictions again. Evidence that steps or voluntary action has been taken to remedy the problem. There's been a high level of cooperation with the investigation itself. Good health and safety record. I'll not read them all out, but age plays a factor as well, lack of maturity of the offender, and if they've got any mental or learning disabilities that has affected them. Now, in addition to these 2 tables that reduce the seriousness, early guilty pleas will also be taken into account as a factor in reducing the sentencing, as will any assistance given to aid the prosecution themselves. Now, I think that a good piece of advice to take from this is that we can refer to a HSE document, guidance document called INDG 417, which is Leading Health and Safety at Work, which is actions for directors, board members, business owners and organisations of all sizes. This will set the standard for which needs to be followed to avoid potential prosecutions. So all I've done is, at the very last slide itself, I've put a web link to the Sentencing Council, where you'll be able to download a copy of the sentencing guidelines, and also a link to the website that contains the INDG 417 document. So I would recommend that you would certainly, following this webinar, download the Sentencing Council guidelines, but also if you've not got a copy, it's worthwhile looking into INDG 417 as well. And then finally, I'm going to open it up. Does anybody have any questions about anything that I've covered at all so far?